This case is about the taxation of profits made by a limited liability partnership called HFFX, which carries on trading in foreign exchange. The profits which HFFX generated were very large. In an effort to minimize the tax to be borne by the individual partners, HFFX devised a complex deferred remuneration arrangement involving a capital allocation plan. That plan involved allocating substantial sums of profit, representing the deferred remuneration element for individual partners, to a corporate member of the firm known as GSAM to constitute a fund designated as special capital. At the same time, the individual partners would be given an indication of what element of the special capital represented remuneration for them, which could be drawn down by them later on. However, although in ordinary circumstances they would eventually receive the sums indicated, GSAM had a genuine discretion as to whether it did in fact make payments to them. Payments would only be made if the individual partner behaved in accordance with their obligations under the partnership deed, if the business did not suffer losses, and so on. But the discretion was constrained in that the discretionary power had to be used rationally and for proper purposes under what are known as Braganza obligations, after the name of a well-known case. This case raises two questions of tax law. First, HMRC maintained that the individual partners should be taxed in each particular tax year on the indicative amounts of deferred remuneration indicated to them derived from HFFX's profits for that year. HMRC relied on Section 850 of the Income Tax, Trading and Other Income Act 2005, which provides for a partner to be taxed on their share of HFFX's trading profits, quotes, in accordance with the firm's profit-sharing arrangements during that period, close quotes. On that question, the first-tier tribunal, the upper tribunal, and the Court of Appeal ruled against HMRC. HMRC have appealed to this court. The court dismisses the appeal in relation to Section 850 and upholds the reasoning of the Court of Appeal. The key point about Section 850 is that it creates a notional division of profits to partners to count as their income to the extent that they have rights which subsist in the relevant tax year to receive a particular share of the profits. But in relation to the profits which were diverted to GSAM to provide for deferred remuneration payments later on, the individual partners had no right to receive them, which subsisted in that year. This was precisely because GSAM had a discretion, albeit subject to certain restrictions, whether ultimately to make a deferred payment or not. The second question of tax law concerns Section 687 of the same Act. That provision provides for payment of income tax, quotes, on income from any source that is not charged to income tax, close quotes, under any other provision of the tax code. It is a sweep-up tax provision to catch income which ought to be taxed, but isn't caught by any other provision. HMRC submitted, as their alternative argument, that when the individual partners in HFFX received the deferred element of remuneration, those payments fell to be taxed under Section 687. The partners resisted HMRC's case on two grounds. First, they said that the income had no source as required by Section 687. Secondly, as a new argument in the Supreme Court, they said that Section 575 of the same statute operates to disapply Section 687 if in fact the income falls to be taxed as trading profits, and here they were trading profits of HFFX. On the application of 687, the first-tier tribunal, the upper tribunal, and the Court of Appeal all ruled in favour of HMRC and against the individual partners. They had to pay income tax on the sums received. The individual partners have appealed to this court. The court dismisses the partners' appeal and again upholds the reasoning of the Court of Appeal. The deferred remuneration income was not received as a matter of purely voluntary payments made by GSAM, because GSAM's discretion was constrained by the Braganza obligations. A combination of a legal framework involving such obligations to consider making a payment, and the fact that a payment was made pursuant to that framework, meant that there was a source of the income received in the relevant sense. Section 687 therefore applies and provides a basis for the taxation of the individual partners. The Court dismisses the partners' new argument based on Section 575 of the Act. The income the partners receive is distinct from the trading profit or income which HFFX received and then paid on to GSAM as part of the deferred payment scheme. The priority rule in Section 575, therefore, does not operate to disapply Section 687. The overall result, therefore, is that HMRC have lost in their attempt to tax the individual partners under Section 850, but HMRC have succeeded in their claim to tax the individual partners under Section 687. The Court is now adjourned.